All rise. The Court of Appeals Division 1 is now in session.
Thank you, folks. Have a seat. All right, and good morning. We are here for oral argument in case number 1, CACD 25-0139, Krishnan v. Krishnan. These proceedings are being videotaped and they are being simulcast, live stream. So we do ask that when you approach the podium, please state your name and the party who you represent so everybody's clear who's speaking. Each side has 20 minutes. Counsel, you're responsible for watching the clock and reserving a portion of your time that you want for rebuttal. You're welcome to tell us, but we will not guard it for you beyond maybe noticing that you're going into it and commenting on that. But otherwise, it is your responsibility. Please keep in mind we have read the briefs and we've conferenced the case this morning. We are familiar with it and we understand it's a very narrow issue. You do have 20 minutes. Don't feel that you have to use them all, but please use the time that you feel you need to make your arguments so that we understand them. But I would counsel against just repeating the briefs. With that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court, I'm Al Arpad for the appellant Venkatesh Krishnan in his personal capacity. I'd like to reserve a few minutes for rebuttal. I don't have strong feelings about how many, but at least a few, because I don't still think that I understand the appellee's argument here, and I'm afraid I'm missing something. That's one reason that I requested oral argument. The other reason is because I think the probate bench and bar really needs a case, a published case, saying what 141105 means and doesn't mean. And I wanted to make sure we had a chance to answer your questions, or at least try to answer your questions, because the proceedings below were a little bit complicated. I also think it would be valuable to have a little clearer guidance on the other issue that we raised, that there ought to be some kind of notice of what statute we're proceeding under when people award attorney fees. And I don't know exactly what that has to take. In a contempt hearing, you might just say, I'm going to find you in contempt if you don't shut up now. And maybe that's enough warning. But in these proceedings where you've got a substantial amount of money at issue, it seems to me either the court or the person who's applying for the fees needs to say what the statute is.
Mr. Arbart, why don't we talk about that first point there? Isn't it correct that 141105 was a stated basis for an award of attorney's fees in the petition and the amended petition here?
Yes, that's true.
Okay. So your client was on notice of the possibility that they would be seeking fees under that statute, correct?
Back at the beginning of the case.
Okay. So is it your position that, for instance, obviously what happened here is we have the court issue its order essentially saying I'm dismissing this within 20 days, and if anyone wants to apply for attorney's fees, speak now or forever hold your peace. Is it your argument that your opponent needed to state a specific basis in their application in addition to the notice that you received in the petition and the amended petition?
Yes, either the court or, under the circumstances of this case at least, either the court or the appellees needed to do that. And two reasons for that. One is that by the time we get to the proceedings that are at issue here, the proceedings on the petition had been concluded. They had been given permission to dismiss it, and the order dismissing it, the final form of the order didn't appear until halfway through these attorney fee proceedings, but it says the attorney fee claims under the petition are dismissed. That had been dismissed. This is a whole other issue, and it's not just different.
It expressly said, and it expressly said the attorney fee provisions are dismissed or the petition's dismissed?
It said the petitions are dismissed, and I believe it gave 1, 2, 3, 4, 5 different types of claims that are dismissed, and number 5 was attorney's fees. Aside from that sort of procedural issue, the facts had changed. Under the petition, they were claiming that my client should be removed and somebody else should be put in, and so maybe somebody could have qualified on their side for attorney fees under 141105 because they would have been the fiduciary in that situation. They're not anymore. Somebody at some point has to give my client notice of why they think 141105 applies in this situation. It just doesn't make sense.
Were you prejudiced in any way by their failure to specify a 1411? I mean, they stated, if I recall correctly, two different grounds, 141105, and I can't remember the other provision that they put in the petition as a grounds for an award of attorney's fees, but it wasn't like it could have been anything. I mean, there was a fairly limited category or a fairly limited set of statutes under which they could have been seeking attorney's fees. Would you agree with that?
I'll give you two different answers to that one. First of all, we're very prejudiced if you accept the other side's argument that we waived arguments about 141105 because we didn't bring it up specifically, because we don't think it was our job to bring it up specifically. But the other interesting thing here is that the probate statutes, Title 14, has another statute, 141104, and the specific language of that statute is kind of different and, in my opinion, more ambiguous. Nobody has claimed that that applies, and so I certainly hope we're not going in that direction. But in order to know what arguments to make, my client really did need to know what statute we were operating under.
Now, and just taking this out of the probate context and addressing it as a sort of regular civil case, if I file a breach of contract action and I cite 14.34101 in my answer to the complaint or in the complaint itself, if I seek attorney's fees later, everyone kind of knows what basis that is based on. Are you suggesting that here that the probate rules are necessarily somewhat different, that in your application for an award for attorney's fees you need to essentially pick and choose or re-specify what basis that you are using to seek fees?
I do think you're making a very good point, because in a contract case, everybody knows that 12.34101 is the likely basis for fees. And
But not the only one.
No, not the only one. There are lots of other things could apply, and if it's something else, you probably do need to say that.
Well, you do need to say it, don't you?
But you even need to say 34101, don't you? I mean, you still need to say it, even though...
And it needs to be in the complaint.
Well, it needs to be in the complaint, and in a normal case that proceeds from complaint through trial, maybe it's not as critical because everybody knew all along what you were talking about. This case is a little bit strange, and many probate cases are a little bit strange because they go through, for a lot of reasons, but for one of them is that they go through phases and different things happen and people can change capacities. That's often a lot of the relief that's being requested. So in probate court, I think it is particularly important, and in probate court, the statutes are a little odd because they don't say everybody gets to apply for fees. They say some people get to apply for fees.
Now, there's another way that this court could have awarded fees or essentially gotten to the point where your client had to pay the attorney's fees for the other beneficiaries. They could have surcharged your client, for instance. Would you agree with that?
Yes, those are substantive proceedings, which is different under 54 and 58 than attorney fee proceedings. But
correct, and that's not what the court did here. I think I agree with you on that point, but there was a way to get there if the court wanted to do so. Would you agree?
Yes, if the beneficiaries had they were saying that type of thing. I mean, that's what a lot of what their petition was about, was that he had delayed and he had wasted and he had, not charged enough rent and all kinds of other things. And so that would have been a potential substantive relief under the petition. And again, that was dismissed by the time we got to any of these proceedings.
But in contract cases, they dismiss cases all the time, and then the attorney fees are decided afterwards. The attorney fee claim doesn't go away when someone prevails in a dismissal. It still exists. How is it that it evaporates here? What's your argument that it evaporates here when it doesn't in any other case when there's a statutory right to fees based on the nature of the case?
It evaporates here not because it was dismissed. It evaporates here because the statutes don't apply to the situation that existed.
But you also said if they don't assert it, the court said this case was dismissed, it even included attorney's fees in the order, that we would not deny attorney fees in a contract case based on that. Why would it be different here?
I think there actually was a case the other day, depending on what happens under Rules 54 and 58, which have become increasingly complicated, denying somebody fees because it wasn't in the order and they didn't file a Rule 59.
Not what I'm asking. I'm saying when a court dismisses and a party then pursues its attorney fee case before the order's signed, timely and everything, which is what happened here, that the dismissal somehow precluded it. That's how I understood your argument to be. And I don't see it.
I don't think that's the argument I'm making. Your Honor.
Okay,
I
then
don't
we can
think
move
it's
on.
the dismissal that precludes it. I think it's that somebody needed to say what we're proceeding under here
Okay.
because there aren't any applicable statutes in the situation that existed after the dismissal.
Well, there are applicable statutes. They could have gone under the other provisions and surcharged. You're saying the one, then moving to the core of this case and the crux, the one that was used here doesn't apply, is really your argument. And I think if we stay to this case, which is what we do, we don't go searching around the universe for other things. Let's talk about the statute in this case. Why does the statute in this case not apply?
There are essentially four elements in this statute. Number one is it says that the court has to find that the decedent's estate or trust has incurred professional fees or expenses. Now, it's interesting because the statute is broader than a typical attorney fee statute. It says you can get lots of different kinds of fees and expenses, but it's narrower in the sense that it only applies to fiduciaries. And there's a B section that applies in guardianship and conservatorship cases. And the expenses have to be incurred as a result of unreasonable conduct. So there's got to be a causal relationship. It can't be, as the appellees were arguing, well, it was sort of a make-up for money they didn't get earlier in the case.
And you're not arguing that the fees awarded weren't because of conduct. You're not trying to say, oh, they were excessive because they were for other things.
We made fairly detailed arguments about why our client's conduct wasn't unreasonable in the various different motions that were filed in the post-dismissal.
Right.
So we argued substantive unreasonableness too. But I'm also saying they seem to have made various arguments that because they had incurred a lot of fees earlier in the case, the judge could do this as a sort of a make-up here. And I'm saying, no, they can't do that.
You haven't asked us, though, to review that. I mean, you're saying we don't owe them at all. You haven't said, I don't think you've asked us to go through and piecemeal and see if we think the Superior Court, the fees themselves were erroneous beyond the statutory award.
Well, part of our argument is that if you think the statute applies, which I think it clearly doesn't, so you
Right.
probably don't have to get to it. But if you get to it, there were, I think, 7 different categories of
Okay. things,
and we said each one of them, our client's conduct was in fact reasonable, and at least some of them should have been excluded.
Okay.
So the third, it gets to, it says we're going to pay some or all of the fees and expenses. I think when it says the fees and expenses, it has to be referring back to the ones that were incurred as a result of unreasonable conduct. So again, same fees, not make up for some different set of fees and expenses. And the fourth is that the payment has to be ordered to the estate or trust. Literally none of those apply to the situation here.
Let's focus on the last one.
Yes, Your Honor.
Go ahead.
They're being ordered to be paid to beneficiaries, not to the estate or trust. It just doesn't apply. And I think we even gave you a reference to the committee that came up with this that said that they wanted to, their specific situation was that when people took on a fiduciary role in the probate court, which can be pretty darn burdensome, and sometimes you have a lawyer and sometimes you don't, they wanted to give those people some recourse if other people were making their lives unreasonably difficult. That's the purpose. It's one-sided. It's unusual in our system to have an attorney fee or expense statute that is one-sided, but that is in fact what it is. As far as I can tell...
Is there any case that's ever said it goes beyond the estate or trust that you're aware of?
I believe there was an unpublished case that awarded to someone that didn't appear to qualify, but it didn't go into it at all. I think I remember coming across that somewhere.
In other words, it wasn't an issue, it just appears like in the facts.
Yeah,
that
it just says somebody requests fees under 1105 and we uphold that. And that's a vague memory. I think there was one that I came across. It was unpublished.
Okay.
I came across a nice Superior Court case out of Pima County saying, no, this is only awardable to the fiduciaries, but that one doesn't count either. So I think the
No,
answer
it
to your
does not.
question is no.
All right, thank you.
And to add to what I just said, the trust counsel was trying to withdraw and was not getting paid during all these post-dismissal proceedings. So there wasn't even a fiduciary who was incurring expenses in a fiduciary capacity that would have been eligible for those types of fees and expenses.
Is there any argument they stand in the shoes of either the estate or the trust?
I think that's what the substantive petition would have been about. They were trying to, and they didn't. And by the time you get to the end of it, no, I don't think there's any plausible argument for that. Unless, I mean, they did essentially say, you should grant this to us because we incurred a bunch of fees and expenses and lost money before. But again, the statute clearly doesn't apply to that. Again, they say the argument was raised for the first time on appeal. I've said you should not apply that in this case because we didn't know what statute we were arguing about, so we couldn't raise it specifically. And we said no statute applies, is what we said. And as I said, we made a number of very specific arguments. If you somehow find that the statute applies, that the award should have been a lot smaller because most of those proceedings weren't our fault and we didn't do anything unreasonable in each of 7 specific categories. Unless you have other questions, I'll reserve the rest of my time.
Good morning, Kathy Sandweiss for the Appalese, who are Suchi Krishnan and Sundar Krishnan. I want to back
And they're
up.
beneficiaries.
Yes. I want to back up a little bit and talk about what this appeal is really about. It's about their brother, Venkatesh, having disobeyed, violated court orders, and that's what he was sanctioned for. The trial court made...
Does Section 14-1105 deal with sanctions? Is it a sanction statute?
Well, I will get to whether that specific statute applies. I don't think, to be candid, that's our best argument, because I believe Appalee's best argument is that this court will affirm on any legal basis supported by the record, Your Honor. And because the trial court made factual findings of delay, of conduct without substantial justification, and those are factual findings that are reviewed for abuse of discretion, this court can affirm on any legal basis supported by the record.
Okay, so if that, let's just say that we agree with you and that we agree that the court necessarily made those factual findings. Where are we shoehorning the award of fees here? Is it 12-349? Is it the court's inherent power to sanction conduct? Is it
any of those? So
okay.
the court's findings specifically, I understand that this trial judge found that 12-349 didn't apply, but based upon her own findings, it actually does apply.
But we abuse for an abuse of discretion, and if she took the facts and played them down, what is it that makes you say we should reach a different result? Why?
Because this court will affirm on any legal basis supported by the record. And when you look at this judge's specific findings, she used words like unreasonably expanded litigation, created unnecessary delays, lacked justification. And then you look at, I understand, she said, well, that doesn't meet the elements of 12-349, but to be candid, it actually does. When you look at 12-349A1, defends a claim without substantial justification. That's exactly what this trial court found. And you look at A3, expands or delays the proceedings. The court had been finding ever since October 2021 that Venkatesh expanded or delayed the proceedings. I mean, if you look at the original court order, back in October 2021, when the court said, no, I'm not going to remove Venkatesh as trustee because we're almost near the end of this administration anyway, which then, of course, we weren't. It took 3, 4, or now more than 4 years beyond that. And the court said at that time, this is a sin of delay. Those were the court's words back then, and then the court kept using those words. And so...
Ms. Samwise, can you give us an
Yeah.
example of another case where we have a trial court judge who has issued an award of fees and cited a specific statute on
Right.
one basis, and that this court has come back and affirmed by rewriting that order and changing the basis for the award of fees? Do you have any cases where we've done that?
Well, perhaps. I mean, that would be probably any of the cases where this court has said, we will affirm on any basis that's supported by the record.
But I'm not sure
That's a
we,
bit different, isn't it?
I'm not sure we raise the legal theory for the party. I mean, in raising the legal theory, like Rule 11, 12349, other sanctioning rules or statutes, we rarely, if ever, that I recall, do that. Of course, we will affirm if the record supports the legal theories presented by the parties. We don't create legal theories for the parties.
Right. Well, in fact, the trial court did raise 12349. The trial court set
Well,
forth...
the trial court raising it is a different
Right.
kettle of fish.
And you're kind of asking us to reverse the trial court, aren't you, on that 12349 determination?
Well, I'm asking you to affirm the trial court's decision based upon its factual findings. Now, we can also go back to the petition and the amended petition, remember, where Sushi and Sundar cited not just 1105, but also cited 11004. And so if you, so Venkatesh was absolutely on notice that these were the statutes that were in play here. So if you look at those statutes, 11004, let's see. A trustee or a person who is nominated as a trustee is entitled to reimbursement from the trust for that person's reasonable fees, expenses, and disbursement, including attorney's fees and costs that arise out of and that relate to the good faith defense or prosecution of a judicial or alternative dispute proceeding.
Ms. Samwise, the very first clause, is your client a trustee or nominated to be a trustee?
Yes. Our client was absolutely nominated to be a trustee. So what happened was the parents, remember, were the trustees initially. Venkatesh was the first successor trustee. Then Sushi was the alternate trustee, the first alternate trustee, and Sundar was the second alternate trustee. And so using this exact language of this statute, a person who is nominated as a trustee, and so both of them would apply under that statute.
Why didn't you ask the trial judge to award fees on that basis?
Well,
I mean, when I look at your fee application, what I see is a fairly vanilla fee application, which doesn't really suggest the basis for why. I mean, it suggests the factual basis, but it doesn't
Right.
provide a statutory basis of, Judge, we want you to use this statute to award us fees.
the trial court didn't require that. Remember, if we go back to, and that goes back to what counsel was saying about how there was a final award that didn't include attorney's fees. And if you look at the order of dismissal that was entered August 22nd, 2024, it was entered as a final judgment under Rule 54C. That was apparently an error because it was not an actual 54C judgment, and I believe there was an appeal out of that, and then this court sent it back because it included the provision that any motion for attorney's fees must be filed within 20 days of this court's order. So, in fact, the court was asking the parties to request attorney's fees, and they did, and in fact, member counsel for Venkatesh had also filed a fee affidavit and an application for his own attorney's fees. That's in the index of record 132 and 133. So then, subsequently, there was an order where the court clarified as to what exactly it was looking for, and it specifically asked for fees related to a specific time period where it had already determined that there had been delays, that its orders had been violated. Its orders from January 5th, 2024 and April 18th, 2024. Fees incurred due to the failure to comply with this court's orders filed January 5th, that's the order directing trustee, and April 18th, 2024 distribution extension order, because remember, distribution was not made when within the time period of that initial order. One day before the deadline for distribution, that's when Venkatesh then filed these additional motions, a motion to alter or amend order, a motion for a stay order, one day before distribution was due. And so at that point, she asked for fees incurred and the additional fees incurred due to the trustee's unauthorized wire transfer and the failure to comply with this court's orders. So there was no reason for Sundar or Suchi or their counsel to now cite statutes because the court had already ordered them to provide affidavits showing their fees and costs incurred at that point. And remember, their fees were substantially reduced. They did not receive fees for this entire case. They incurred fees of more than $300,000, and they received only about $41,000. That's what this is about.
So, Ms. Sandweiss, are you conceding before us today that 141105A does not permit an award of attorney's fees to your clients in that they are neither the trust nor a decedent's estate?
No, I don't think it's the best statute to apply here, but I don't think it doesn't apply at all because the trial court, remember, made some findings as to expenses to the trust caused by Venkatesh's actions. For example,
But the fee award was payable to your clients, not
Correct.
to the trust, correct?
That's correct, although it directly impacted them because fees were taken out of the trust to pay the trustee's attorney's fees.
But the math is different if that's payable back to the trust because your clients are 25% beneficiaries of the trust. And the court, again, court could have done that, could have awarded those fees payable to the trust, which would have, at least a portion of it would have filtered down to your clients, but that's not what the court did here. The court awarded fees to your clients. How do we fit that within the language of the statute that says that you can award to pay the decedent's estate or trust for some or all of the fees and expenses? How does your client fit into that language?
Well, in the
Or your
order of
clients,
12/30/2024, the court didn't cite subsection A. The court cited ARS 141105. And if the court will look at subsection C, it says the remedies allowed pursuant to this section are in addition to any other civil remedy or any other provision of law. The remedies allowed pursuant to this section may be invoked to mitigate the financial burden on decedent's estate or trust incurred as a result of unjustified court proceedings or unreasonable or excessive demands.
But the burden on the decedent's estate or trust, again, that same language which does not appear to apply to your clients.
It was a burden. It was, as Your Honor stated, because it detracted and omitted from the amount of the estate that would have been available for distribution by spending money on attorney's fees for out of the trust and by failing to properly list the Pennington property. Those amounts directly came out of the trust and then were not available. But
Isn't subsection C just this is not an exclusive remedy section?
Yes.
You can look at other things, like 11004. This is not an exclusive remedy if the trust or the estate has experienced damage, and so that's what authorized the judge to use other things, but the judge didn't. Here, the judge awarded beneficiaries the attorney fees under a statute that the legislature limited expressly in plain language to the estate or trust. And under our case law, how do I get around that?
Right. Well, I assume that the judges at this point have seen the Chalmers case, the Arizona Supreme Court case, Chalmers, that recently came out over the summer. And I believe that that is applicable here because it talks about context. And it's not about these specific statutes, but it is about other probate statutes. And it says context is always relevant to statutory interpretation. If a provision is part of a broader statutory scheme, context can tell us the overall objective. Context is essential to avoid rendering other parts of the statutory scheme superfluous. In context means reading statutes as a cohesive whole, so no word or provision is rendered superfluous. So if you read any of these statutes that we've been talking about, you read them in conjunction with 141102, which we haven't talked about, but I think this is really important because it's sort of an introductory purpose statute to the entire statutory scheme. And it says, this title shall be liberally construed and applied to promote its underlying purposes and policies. And then it says, the underlying purposes and policies of this title are, and it goes through some factors, and then subsection 5, to provide just and appropriate remedies for parties who incur damages as the result of vexatious conduct as defined by court rule or other unreasonable conduct during proceedings brought pursuant to this title. So when
couldn't the legislature have simply said any person, who suffers loss, couldn't 1105 say that? But instead, 1105 specifically says the decedent's estate or trust. And there are other provisions under the law, Rule 11, 12349, some of the ones that we've discussed already, maybe 11004, that could have allowed your clients to be awarded attorney's fees, but that's not what the court did here. So why should we rewrite the court's order awarding fees to pick an applicable section of the Arizona Revised Statutes when that's not what the trial court did here?
Well, one reason is because, and I actually think this is very important, this issue was waived. It was not discussed at the trial level whether this statute applied.
Well, didn't they raise an objection to your application for attorney's fees saying you haven't identified a basis for the award of these fees?
No. If you look at the motion, for new trial, it's really interesting. What he says instead is, I was the prevailing party and I should have been awarded my attorney's fees.
And I'm talking about the response to the application for award of fees. Does he not raise the argument that you have not identified a specific basis for this award of fees?
No, he never, no. I'm not certain about that, but what he doesn't do, and you may be correct on that, but what he does not do is engage in the conversation as to whether 1105A would apply. Now, I understand the reason would be because no statute was cited in these applications for attorney's fees. However, again, going back to that was the court order, and so there was no reason they didn't believe that they had to say the statute because, again, as Judge Goss has stated, sometimes we do that in complaints. We state 12-340-101, we state 12-349, we state the various statutes that might be applicable, and then we don't necessarily have to state them again, particularly in this case where the judge has already stated, I'm going to award you attorney's fees based upon this misconduct.
Okay,
so they go
the
ahead
question I'm asking you, though, is an objection saying you have not identified a valid basis for an award of fees, is that not sufficient to preserve that issue for appeal?
No, because remember, now his specific issue is 1105A doesn't apply. And remember why we talk about the doctrine of waiver It's because we want the trial court to correct its own errors. And when this was raised in the opening brief, I went back to the briefs as the appellate counsel. I thought, oh, well, how did they address this? How is it addressed? How did they say they were within 1105? And it was never engaged. They never gave the trial court an opportunity to correct, if it was an error, to correct its own errors. And they had the opportunity, and I understand that appellant's argument is, well, we didn't even have to file a motion for new trial. Well, that's right. They didn't have to. But that means that the appeal is based on the record that's before this court. And there's no record of any argument about applicability of 1105A. So what now they could see, they get this order, and the judge is saying, I'm applying 1105, not A, just 1105. And at that point, they knew they were going to raise this on appeal. So now in filing a motion for new trial, that was their opportunity. They could have raised it then, and it would have been fleshed out at the trial court level. And it never was. So it is really important, and I understand that a lot of times waiver is just a footnote in this court's cases. I see this all the time. Well, that issue wasn't raised, it's waived, and it's a footnote. But it's really important in this case. It's important because it was never fleshed out at the trial court level. So I know I'm out of time, but I do just want to point out the three then important issues. I do want...
I'm not going to let you go do a rehash, but thank you.
Okay, thank you, and I would request that the court affirm.
Thank you. Counsel?
I agree with opposing counsel on one thing, is that this should have been fleshed out at the trial court level, and that's why you need to have notice of what statute you're talking about in order to flesh it out at the trial court level. I think, frankly,
would you address her specific point about the fact that this argument that 1105A doesn't apply, it does not appear in your motion for a new trial?
I believe we gave you specific citations to the rules in the reply brief, but we are not required to file a motion for new trial in order to preserve issues for appeal in Arizona. Some states you do, not in Arizona. We file an extremely narrow one based on a subsection of 54H that says you have to do that if you are the prevailing party and you think you might want to appeal. We didn't do a long one because we probably would have been hit with more fees for it, and we weren't required to. So that's how I address that. Does that answer your question?
It does. Thank you.
I think it's quite possible that this judge would have not made this ruling if it had been explained to her that 1105 doesn't apply, or if it had even been cited. And oddly enough, she cites it, and so she probably should have.
Why can't we do what counsel wants us to do? Say, hey, all the findings support a 1249 award. Let's just move it over into that box, and we can affirm on that ground.
I don't think there's any authority for it, as your honors have suggested, but also 12349 is a rather different high bar standard, and as you indicated, you would have to overturn the trial court's ruling on that in order to get to it and say that the conduct was worse than the trial court thought it was, and you would have to apply it to each of those 7 different categories of conduct that we talked about in our motion, and I don't think it comes anywhere close.
Couldn't we just say 12349 applies and remand to the trial court then to do that analysis under 349? The further analysis under the 7
I certainly
subsections?
don't think you can say 12349 applies. You could conceivably ask the trial court to reconsider, since it already said it doesn't think 12349 applies. I don't know what the basis would be for that, really. I do want to point out that when counsel keeps saying that there were findings that we violated orders, those findings are from an order that was submitted ex parte and that we never even got a chance to respond to in the trial court. Those are not the trial court's findings.
Did the court sign it?
The court signed it.
And they are the court's findings.
Without an opportunity to respond?
Did you object based on the failure to?
Yes, we did.
And did the court overrule it, or do you hear your response?
The court heard the response.
And then the court ordered it.
Overturn it.
Those are court orders, my friend.
It is a court order, but it's a rather weak basis for a 12349 finding. I don't have a lot else other than to point out that I don't think 141102 applies, and I certainly hope we're not going off into 141104. But I did want to point out a housekeeping issue. I realized in preparing for this that I had failed to file the transcript of a hearing that is cited in the opening brief. Turns out it's really not terribly relevant. It's a 20-page transcript, and I talked to counsel before this, and we agreed it's probably not terribly relevant, so I will just suggest that that paragraph on page 9 and 10 you ignore. This is my notice of errata. You ignore the references to things that were not filed and go on. But if there's any reason you want to see the transcript, as I said, I don't think it's terribly relevant, but I'm happy to file it. That's all I have.
And so you're asking us to strike, be very specific in what
On
part of the
pages 9 and 10, there are several sentences that reference a transcript. The transcript was not filed. I don't know that you need to strike it, but you can just ignore it because
I think the wiser move is to strike it if you're conceding.
the transcript was not filed.
Okay. Then I think if folks are okay, we'll issue an order striking that. We'll be very specific as to what's struck.
That's fine with me, Your Honor.
Okay. Thank you, counsel.
That's all I have. Thank you.
All right. Thank you, folks. We appreciate the argument and the briefing. We will take this case under advisement and issue our ruling in due course.